Yeah. So go ahead. So, live Lama.
Yesterday, good evening to all of you. Yesterday we were just dealing with Kalyangar. 1 minute. Right, quick. Only we did different name. So yesterday we were just dealing with restitution of conjugal rights. It's almost akin to Section 9 of the Hindu Marriage Act, but the corresponding provision to the Indian Divorce Act is Section 32. What do you exactly mean by restitution of conjugal rights? Here, suppose the wife or the husband lived separately, or let us say the wife, without any justifiable cause, withdraws from the company of her husband, and in spite of the best effort of the husband to secure the company of his wife, she does not return, or vice versa also. Or the husband is so reluctant to take back his wife, and the wife is very much interested to join the company of her husband and continue her marital life, then in that case, either side can file a petition for restitution of conjugal rights under Section 32 of the Indian Divorce Act. And then the answer to the petition is normally the defenses that are taken is if the wife is a respondent, she says that I'm unable to bear the harassment of my husband, and my husband harasses me physically and mentally, and he has subjected me to mental cruelty, and it's impossible for, and there's danger to my life and limbs if I live with my husband, so I'm not prepared to join him. So various defenses are open, or let us say the husband is addicted to alcohol, or is addicted to vices, or is living a wayward life. Then in that case, the wife is justified in living away from the husband, and no restitution of conjugal rights decree can be passed. This is what we did it till day before yesterday. That is section 32. Section 32. Then, then next one is we go to the next chapter called alimony. What do you exactly mean by alimony? Yes, what do you exactly mean by alimony? Alimony means maintenance of the wife after the marriage, after the decree, or then in that case, or let us say everyone is entitled to keep her body and soul together. The wife has no independent means of livelihood. She is unable to sustain herself. Then in that case, the husband is well placed. Then in that case, she can always file a petition for pendenti alimony. Pendenti alimony means pending the case for divorce or whatever it is, she can ask for maintenance to be paid by the husband to her. And normally under the Indian Divorce Act, till the couple are separated from each other, the husband is bound to pay the alimony pendentility. This is almost akin and similar to Section 24 of the Hindu Marriage Act, which speaks about maintenance in pendentility and legal expenses. So this in the Indian Divorce Act, the provision is Section 36, and permanent alimony is granted only after the decree is passed. Wife also has to sustain herself. Wife has to maintain herself, and wife has to live a life. And she has no education. She has no means of livelihood, and she cannot maintain herself physically and mentally. Then, in that case, a figure is fixed by the court, fixing the permanent alimony as far as the wife is concerned. Here, one thing is distinction has to be made in the Indian Divorce Act. This alimony may be paid in installments also. It can be paid weekly, it can be paid monthly, or it can be paid in a lump sum. But here, the question is, here we differ with the Indian Hindu Marriage Act to say that as far as the husband has got property, 50% of the husband's share is payable to the wife towards their permanent alimony. This is a very beneficial provision as far as women are concerned in the Indian Divorce Act. This is what Section 37 is concerned. Till such time the decree is passed, the property will vest with the trustees, and the trustees will manage the property, administer the property, income arising out of that property. They will have to pay the wife, that is, who has suffered a decree in a suit for in a proceeding for divorce. Then we got what is called antinuptial or post-nuptial settlements. What do you mean by anti-nuptial settlements? Please remember one thing is this: if you have got the history as to how Christianity was born, Christianity, the Christians follow what is called the New Testament, and the Muslims follow what is called the Old Testament. And that is the reason among Christians, I'm sorry, the names are almost similar with Muslims. For example, suppose you say Yusuf, then in Christianity is called Yusa, whatever it is. Then Moses, you will call him Musa as far as Muslims are concerned. The question is, as far as Christianity is concerned, it is also an offshoot of Islam, and that's the reason why Christianity they follow the New Testament, and the Muslims follow the Old Testament. Yeah, sometimes what happens is prenuptial settlements take place. What do you mean by nuptials, sir? I think most of you know. Most of you are married people also. Nuptials mean the first night, or what is called the first night where the husband and wife live together and come together, and post nuptial, that is after the nuptials are over, consummation is over, the husband promises to pay certain some money to the wife towards her marriage settlement. These are called even either prior to the nuptials or subsequent to the nuptials. The question is when the consummation takes place, before consummation or after consummation, if the husband promises to pay certain amount towards the marriage settlement, that amount can be recovered. That is what section 40 speaks about. Next, we go to the custody. As far as custody is concerned, sir, there is a distinction between Hindu law and Muslim law. That is, when the children are there, the question is, as far as male children are concerned, father is the guardian up to 7 years, and as far as the female children are concerned, till the age of puberty, the mother is entitled for the custody. So the question is, once the spouses decide to separate from each other, the position of custody of the children also has been decided and settled by the court, which hears the particular matrimonial matter. That is what section 41 says. Then 42. 42 says that what is the position after the decree? After the decree, suppose the custody has to be settled, then the court decides as to who is the person entitled to the custody, whether it is a father or whether it's a mother, till how long they are entitled to the custody. The court can decide all those matters, taking into consideration the advancement of the minors, welfare of the minors, financial position of the respective parties, and the financial standing of the parties concerned. The court decides the matter accordingly. Then it sues for nullity or dissolution. Please remember, sometimes because the unfortunate scenario, the husband and wife separate from each other. Why they separate? Afterward, they have rethinking, but that is too late. Then the question is, suppose, let us say, it is for nullity or dissolution. Suppose then it is said, suppose children are there, and when the decree is passed on the ground of nullity or dissolution, then the question of even then, the custody of the children is considered or decided by the court in the same proceeding. Then we go to the procedure that is followed in the courts. Then section 44, 44 deals with CPC. All the provisions of CPC, that is Civil Procedure Code, applies as far as divorce proceedings are concerned under the Indian Divorce Act. And then the forms of petition and summons. As far as the forms of petitions are concerned, it is also prescribed. That is, if you go through the rules, if you go through the schedule, the form of the petition also is given. In what format you have to write, what are the grounds you have to urge, what are the grounds you have to stress, what are the grounds you have to allege and state and prove before the court. You have got the rules, and like Hindu Marriage Act, in the same way you will have to present the petition in the form that is prescribed. And it's also said summons. Please remember, as far as all matrimonial cases are concerned, special forms are prescribed. Under the relevant Indian Divorce Act, if you are not able to get it in the printed form, you kindly look into the Civil Rules of Practice or the Indian Divorce Act. You will get the form, and according to that, the notice forms have to be sent to the opposite side. And preferably, when you file it for the first time, it shall be sent by court as well as by registered post. That is what section 46 deals with. Then we go to 47. Most important thing is there shall not be any collusion, there shall not be any arrangement, There shall not be any fraud played on the court, and it should be a genuine petition. It should be a bona fide petition, and all those grounds will have to be clearly stated in the petition. And if you don't state it, your petition will not be numbered. This is what section 47 deals. Then 48 deals with lunatics. 48, 49 deals with lunatics and minors. As far as marriage with lunatics are concerned, minors are concerned, who are incompetent to enter into a contract, those marriages are supposed to be void and they can be nullified also by decree for nullity. Because as far as lunatics are concerned, minors are concerned, they are incompetent to enter into a contract, so the marriage with them is null and void. Then service. What do you mean by service? Once a petition is filed, the notice of the petition has to be served on the opposite side. Unless you serve the notice on the opposite side, your case will not be taken up. So service is normally done to the court. The next one is taking evidence. As far as taking evidence is concerned, 51 and 52, 53 deals with what is called. Please remember, whenever matrimonial proceedings take place, dirty allegations are made. I'm talking about both sides, be it the wife or be it the husband. And please remember, once I was sitting in the family court in Hyderabad, and the wife abused the husband with that word, which I think I don't want to repeat that word. Then the husband also repeated a word which is unpalatable and unparliamentary. And then the court said, you recognize each other's competence and each other's position. Please try to avoid it. Before you can call me any names, please proceed with your submissions. Then the court jokingly said, there's one of the occupational hazards as far as family courts are concerned. Then unfortunately, I was sitting in the court. I told the court, sir, this is the sin you commit when you say in section 13, advocates are not entitled to represent the party. They do not have free entry. They must take permission of the court under section 13. And advocates can at least control the parties, but a court cannot control the parties. This is a natural phenomenon which is prevalent in matrimonial court. That is the reason I could tell you with confidence, you can conduct 10 cases, but you cannot conduct one matrimonial case. Please remember, it is free for all. And that is the reason whenever matrimonial cases take place, they are held in closed doors. They are held in camera. Parties are not, they except the parties and the bench clerk and the respective advocates and the presiding officer. No other person is allowed to sit in the court or sit in the chambers while evidence is being recorded. It is normally done in camera. Then, next 54 deals with what is called adjournments. We are all, please remember what we were taught when we came to the profession is a person to be successful in the profession should master the art of seeking adjournments. You have got Order 17, Civil Procedure Code, where it says, sir, my senior is not here. My senior is not there, not able to come, sir. Please adjourn the matter. Court straight away will not adjourn the matter. You say, sir, if you're not adjourning it, at least post it tomorrow. You know that the court is not going to post it tomorrow, automatically be adjourned. So here it is said sometimes some situations arise where you have to seek an adjournment on genuine grounds being shown and a petition being filed. You can always seek adjournment under section 54. But please remember, as far as the family courts are concerned, matters have to be disposed of within 6 months. But reality shows cases are pending for the past 3 to 4 years in family courts due to various reasons. Then, sir, 50 enforcement of appeals from orders and decrees. As far as enforcement of what is called appeals from orders and decrees, please remember in the civil law there is one gospel truth that appeal is a continuation of the proceeding before the lower court, and the proceeding does not end with the lower court. It continues till such time the appeal is heard and disposed of by the appellate court. Suppose, let us say, the lower court, that is the family court, orders for divorce, nullity, or restitution, it is appealable, and the appeal lies not to the district because the family court itself is a district court. An appeal lies to the High Court under the provisions of Section 28 of the Family Courts Act, and if it is an appeal from the family court, the period of limitation is 90 years, and if it's from some other court where family court does not exist, it is 60 days. So once an appeal is filed and the appeal reverses the decree of the lower court, Then what happens to the decree of the lower court, sir? Decree of the lower court gets merged with the appellate court decree, and what is executable is only the appellate court decree and not the lower court decree. But for enforcement, again you have to go to the court of the first instance for an execution petition or whatever remedy is open to you. You will have to go to the lower court. But please remember, appeal is supposed to be a continuation of the original proceedings, and once the order is reversed, judgment is reversed, then in that case, the lower court decree or the lower court judgment goes out of shape. And such order, even far past in appeal, can be enforced as far as the family courts are concerned. Then, next one is, please remember, there is also a continuation of this. If costs are imposed by the family court in a proceeding under the Act, there is no appeal provided for filing an appeal against the cost awarded by the court. And next one is, Section 56 deals with what if the High Court rejects your appeal, you have got a right of filing an appeal before the Supreme Court under Section 56 of the Indian Divorce Act within 90 days. Then next one is, then the question arises, within what time a person can marry after a decree? A person has to wait for the appeal period, that is 90 days, and then after that he is free to marry anyone, and that is Section 57. Then 58 is, suppose sometimes what happens is, these Christians are supposed to be very, very conservative. Suppose a clergyman who that is what is called the minister in the Christian language, refuses to perform or solemnize a marriage between Christians regarding more particularly a divorced woman in his church, then he can direct the parties to go to some other church and get the marriage solemnized. Then 59 deals with English minister refusing permission to perform ceremony or permit use of his church. Please remember, sometimes what happens is, we are strangers in our own country. We are strangers in our own community. We are strangers in our own caste. We are strangers because we observe conservative rules. And first and foremost is, the church does not encourage divorces and matrimonial proceedings, but sometimes it so happens. So the question is, suppose the officiating priest or the minister concerned or the clergyman refuses to solemnize the marriage between a widowed lady and another person, then the clergyman can direct the parties to go to some other church and get the marriage officiated and solemnized, but he refuses to do it. Then Section 60 deals with separation or protection order valid to persons dealing with wife before reversal. But please remember, suppose let us say protection order. What do you mean by protection order? The protection order is, suppose the wife wins the case, naturally the husband will have restitution. But till such time the appeal period is over, the wife will have protection from the police and she has to be protected from her husband or the goons which try to attack her. Then 61, that is payments, 61 deals with what is called persons making payments without notice of the reversal or decree or protection. Suppose the payments are made, sometimes the court will order the return of the money because the decree has been reversed. But in future, the payments need not be made. Then bar of suit for criminal conversation. Please remember, a suit does not lie for criminal conversations. Please remember, sometimes defamation is resorted to both by the husband as well as the wife. And it is all, please remember, thanks to IT, we don't have any privacy now. It is recorded. You find it in the CCTV. And let us say that also comes up in the court by way of evidence. You cannot prosecute the husband or you cannot prosecute the wife as far as criminal conversations are concerned. They are not punishable. A suit will not lie for defamation. Now, sir, the question is, what are the new amendments and to what extent it has had an effect on the Indian Divorce Act? Please remember, I told you in the introductory class itself that Christians were bound by the Indian Divorce Act of 1869. It was more on paper rather than implementation. Then Christians raised the hue and cry. And please remember, I told you Christian churches especially, they are very much against divorces, very much against matrimonial proceedings. They will try to unite the couple as far as possible, and only when it is inevitable, it ends in matrimonial proceeding. But slowly what happened was you cannot have everything static for all the time. In 2001, the Christian woman started revolting and said, when Hindu Marriage Act provides for divorce, provides for judicial separation, provides for RCR, so on and so forth, why not the Indian Divorce Act also provide for it? And on the pressure of the Christian community, the Union government passed the act called the Indian Divorce Act of 2000, Indian Divorce Act of 1869, as amended in 2001. One of the most drastic provisions which was introduced was Section 10 was amended, sir. Under the old Section 10 of the 1869 Act, adultery, conversion from religion, person of unsound mind, or let us say a person convicted of rape, sodomy, or bestiality, only in those circumstances you could ask for divorce. And especially when adultery is alleged, you will have to make the adulterer or the adulteress also a party. And the adulterer and the adulteress also, adulterer means the male, adulteress means female, also a party, and both have to be heard, and both have got their respective defenses. Please remember, adultery is a most difficult provision or most difficult attack, ground of attack, which can be proved and established in court. Please remember, no one commits adultery in open, in public. It is done within the closed doors. And to prove that now, of course, you say that your CCTV is there, your cell phone is there, messages are there, then you've got the laptop where the messages are recorded, or let us say you keep a speaker there, it is recorded, a microphone there, and it reaches you. Please remember, here the question is, these things, adultery, it is easier said than done. So that is the reason why the the Indian Divorce Act was amended in 2001, where they provided all the provisions which are applicable under the Hindu Marriage Act or the Special Marriage Act for dissolution, for divorce, or for judicial separation are now available to you as far as Indian Divorce Act is concerned. The first ground which is available to you is mental cruelty. Mental cruelty. Please remember there are two types of cruelty, sir. One is called mental cruelty, another is called physical cruelty. Physical cruelty means all of you know it is marampiti. But as far as mental cruelty is concerned, where it affects the brain of a person, where a person loses his mental balance, where a person is not able to concentrate on his work, where a person has suffered mental agony and anguish because of the attitude of the other spouse, and let us say the question. I gave you instances also. Suppose the wife, before the husband goes to the office, she has a handful of chili powder and tries to sprinkle it on the eyes of the husband, or let us say she tries to pull the shirt of the husband, or she tries to pull the pant of the husband, she tries to pull the shoes of the husband, or let us say she goes to the office and defames or brings down the character of her husband in the eyes of the relatives and friends, or let us say she indulges in certain acts where a person loses his mental balance, then in that case it is called mental cruelty. But as far as England is concerned, along with mental cruelty, physical cruelty also should be there. Unless both are present, the question is you cannot sustain a petition for divorce on the ground of cruelty. Then desertion. What do you mean by desertion? Desertion means where a person withdraws from the company of the other side for a continuous period of 2 years and does not resume cohabitation. It is a ground for asking for divorce on the ground of desertion. But continuous 2 years period should be there where they should be separated from each other. Then a petition lies on the ground of desertion. Third one is when a person is converted from Christianity to some other religion. It is one of the grounds for asking for divorce on the ground of conversion to another religion. Fourth one is when a person is guilty of what is called bigamy. Yeah, when I'm using the word person, that means it means husband and wife. When you take a second marriage to the subsistence of the earlier subsisting marriage, it is called bigamy. But I think most of you are aware of the Supreme Court judgment. Am I right, admin? As far as bigamy is concerned, bigamy is not a criminal offense as of today. That is for section 497 and 494 of the old CRPC has been struck down by the Supreme Court on the ground, saying that it's a regular practice that a person, though monogamy is permissible among Hindus, but still people take more than multiple wives, and especially in northeastern states, and there's nothing wrong in that. Then the next one is what is called next one is person of unsound mind. I think I need not explain what a person of unsound mind is. That is a person who has, in Hindi they call him a divana, or Telugu they call it pichod. Then another is idiot, a person who does not know what is good and what is bad. He is not able to discriminate between what is good and what is bad. And next one is when there is no consummation. Please remember, as far as consummation is concerned, it is one of the attributes of a valid marriage. Please remember, both the husband and wife will have to enjoy what is called the conjugal bliss. And one of the elements is union in the I don't want to go further because ladies are there. Union in the bed. That is what is called consummation. Then next one is uh, impotency. Impotency means where the husband is not able to consummate the marriage, he is not able to have sexual intercourse, he is not able to give happiness to his wife, he has deprived the wife of his conjugal company. Or I put it the other way around also, virility. Virility. Virility means stiffness as far as the woman is concerned, or the uterus of the woman is not developed, where she is incapable of conception, or whether she is sterile as far as sexual companionship is concerned. This is one of the grounds for seeking divorce on the ground of under section 10. Then next one is if the person is not heard for a continuous period of 7 years by his relatives and friends who have regular contact with him, then these are all the various grounds which are provided in section 10. So section 10 is the doors have been kept open for divorce as in Hindu Marriage Act. As far as Indian Divorce Act is concerned, I could put it straight that real meaning has been given to the enactment called as Indian Divorce Act. Previously, the Indian Divorce Act was 1869 was very, very static. It was very, very conservative. Getting a divorce on Christians under the old act was very, very difficult. And the main ground is adultery. Only on the ground of adultery you could seek divorce. But now the question is section 10, like Hindu Marriage Act, the Indian Divorce Act also has been made liberal. Same thing applies as far as judicial separation is concerned. Same thing applies as far as RCR is concerned, restitution of conjugal rights is concerned. Same thing applies as far as dissolution is concerned. But one thing you must remember, sir, as far as alimony is concerned, as far as a Christian wife is concerned, when she is divorced by her husband, she has got a share in the husband's property, and 50% of the husband's property is liable to be paid to the wife towards alimony. But of course, in Hindus, we don't have it. But here, 50% clear amount is fixed. But in Hindus, it is said one-sixth of the assets which the husband has. But as far as Christians are concerned, she will have a charge to the extent of 50% of the husband's property. Custody is concerned, custody provisions also have been made in the Indian Divorce Act, where the custody will be decided by the court. And please remember, on the Hindu Marriage Act also, in-camera proceedings are held. In the Indian Divorce Act also, parties may request the court, sir, have the proceeding in closed doors. Because please remember, for some people it may be a joke, but people who are really affected, it really affects their psyche, it really affects their character, it really affects their integrity, so on and so forth. That is the reason camera proceedings are provided under the Indian Divorce Act. Then the question is, in section 24 of the Hindu Marriage Act, we have maintenance in pendentility and legal expenses. Here also in the Indian Divorce Act, we have provided two things. What is called alimony pending pendentility and permanent alimony has been fixed. And as far as permanent alimony is concerned, 50% of the husband's income plus the properties owned by him will be the alimony payable to the wife. And it's also said it can be payable weekly, it can be payable monthly, or it can be paid in a lump sum, or it can be paid in installment. But in Hindu law, you don't have installment payments, but in Christianity, that has been provided. Then one more thing is how to draft a petition as far as matrimonial proceedings are concerned under the Indian Divorce Act. The same thing how you adopt as far as your restitution of, as far as your Hindu law is concerned, the same procedure has to be adopted. But as far as forms are concerned, you have got separate forms for it. You may find it in the Indian Divorce Act rules, or you may find it in the in the civil rules of practice also, or in the marriage laws, if you can send, you can find the rules. There you get the printed forms which are available. Then, many of the provisions in the Indian Divorce Act of 1869 have been omitted, and what was repealed by this act was Indian Colonial Divorce Consolidation Act 1940 and 1945. They were repealed. That is Indian Colonial Divorce Dissolution Act of 1940 and 1945 were repealed. So the question is, to summarize, the Indian Divorce Act was the Indian Divorce Act of 1869, and what we follow in the courts today is Indian Divorce Act as amended by the Indian Divorce Act of 2001. I think in the earlier lecture I told you, under the 1869 Act, the presidency towns like Mumbai, Chennai, and Kolkata had extraordinary original jurisdiction. But in all these states today, family courts are constituted. So High Court has divested itself from the extraordinary civil jurisdiction, and only the family courts in Chennai, Kolkata, as well as Mumbai can decide matters arising out of the Indian Divorce Act. So the jurisdiction of the High Court is now ousted, except in appeal, to hear all matters relating to Indian Divorce Act. Then one more thing you must remember is, whether it's Indian Divorce Act, whether Hindu Marriage Act, whether Special Marriage Act, or any other marriage act for the matter, they are all governed by the Family Courts Act of 1984, whereby an advocate is not given direct entry. You are only an amicus curiae or the friend of the court. You can only assist the court in conducting the proceedings, but you have to file a petition under Section 13 of the Family Courts Act to the party, saying that he has no legal acumen, he is not aware of the legal jargon, he is not aware of the procedure, he is not aware of the rules and procedure to be followed in family court. So he wants legal assistance. He wants to engage so-and-so as his advocate to conduct proceedings on his behalf. Then it is filed under Section 13 of the Family Courts Act, accompanied by an affidavit, and also in wakalat of the advocate concerned, who is only the friend of the court. And please bear one thing in mind, sir, as far as family courts are concerned, even if any payment is made by the other side towards maintenance, you don't sign it. You ask the party himself to sign it, because you have no power to sign a receipt on behalf of the party, or let us say, enter into a compromise, enter into a settlement, enter into an adjustment without the permission of your client. You are only an agent of the party and a friend of the court to conduct the process, conduct the case, and you are not, and the courts normally bar you as far as appearing in family courts are concerned. But if you see, family courts, very rarely you find parties conducting the case by themselves. We as advocates also, sometimes we are not aware of the rules, we are not aware of the procedure, we are not aware of the method of drafting, we are not aware as to what are the formalities that has to be satisfied. We do not know about the sections, we do not know about the rules. But how do you expect a party to know all these things? Please remember, when an advocate goes to and file, when a party files a family court case, how much of trouble you get in the section we know. In the section they say, idi ledu, adi ledu, idi ledu, adi ledu. The question is, if the drafting is not according to the rules, drafting is not according to the procedure, this has to be followed, that has to be followed. How do you expect a person to know all these things? It's only a legal counsel who knows all these things. Even sometimes legal counsels also do not know. We have to refer to the books. So that is the reason why Section 13 of the Family Courts Act has been provided, whereby an advocate assists the court as a friend of the court, as an amicus curiae, conducts the case for and on behalf of the party. And please remember, whenever settlements are arrived at, Whenever payments are paid, we ask your client to sign. You don't sign it. Please remember, you have no power to sign on behalf of the party. So this is in short the Indian Divorce Act of 1869 as amended in 2001. We next go to the Dowry Prohibition Act. Please remember, Madam, book one, family law. I mean, marriage act. The Dowry Prohibition Act is a very, very small enactment. It was passed in the year 1984 or 85, where giving of dowry and demanding dowry has now been made an offence, and it is also punishable. Here, this was passed in 1961. Varakatnam, they call it as Varakatnam in Telugu, or they call it as what is called Varakatnam, or what is called Dehes, as far as Muslims are concerned. Whether taking of dowry or giving of dowry is prohibited. But please tell me, sir, which marriage takes place without dowry being given? Especially there are certain communities like Munarukapu, Gauds, even scheduled castes, or other communities, or so on and so forth. Dowry is already fixed. The dowry is demanded. The real problem comes when you try to have avaricious methods. You try to extract money from the wife as if she is a milking cow and demand dowry from our parents. So the object of this that is prohibit evil practice of giving and taking dowry. This question has been engaging the attention of the government for some time past, and one of the methods by which this problem, which of improved property rights on women by the Hindu succession, at the same time ensures that any dowry is given, does ensure for the benefit of this evil. There has also been a persistent demand for such a law, both to exclude presents on the form of clothes, ornaments, etc., which the customary or marriages provided the value thereof does not exceed 2,000 rupees. Such a provision appears to be necessary to make the law workable. Please remember, sir, I've seen marriages where car is presented, motorbike is presented, or anything is present except a woman. So the question is, they used to display it on the platform. Even the car used to be mounted on the platform. And please remember those days, I think when I was married, there was no videos. Videos now, everything is video. We have videos today. Please remember, if a car is presented, the photo comes on the camera. The question is, that's the reason the car is made to park somewhere else. Motorcycle is parked somewhere else, and only the vessels are displayed. So the question is, all the ornaments which you receive, the presentations which you receive, the trophies which you receive, or let us say anything that is given in consideration of marriage, they are all called dowry. Giving of dowry and taking of dowry is prohibited. So far, so good. Everyone will say, I don't want to take dowry. I am a person, a Puritan. I want to marry even without a dowry. Please remember, whether you receive in cash, but you receive in kind. The object of this Dowry Prohibition Act of 1961 is to prevent such evil happening. So, evil of dowry system has been a matter of concern to everyone in view of the ever increasing and disturbing proportions. The legislature on the subject enacted by Parliament the far-reaching amendments which have been made to eradicate the evil. As pointed out by the Committee on the Status of Women in India, the educated youth is vastly insensitive to the evil of dowry and unashamedly contributes to the perpetuation. Government has been various efforts to deal with the problem. See, please remember, higher the qualification, higher the demand, higher the financial position, higher the demand. Irrespective of the girls' higher qualifications, there's no bar to demand dowry. And please remember, dowry is demanded, dowry is taken. They both have to be punished. Who gives dowry and who takes dowry? But please remember something like shop premises, non-commercial premises. Please remember, without paying the pagadi, Do we get a shop? No. In the same way, dowry has become an evil which has to be eradicated, which has to be removed. Higher, even in spite of the qualifications, in spite of the education, in spite of the financial standing, in spite of the economic standing, still men are avaricious to extract as much as possible from the girl side. And you don't forget, you forget for a moment, if you have daughter, you have sisters, or if you have daughters, the same situation would arise to arrest this evil, to eradicate this evil, and to see that dowry is punishable, demanding dowry is punishable. This enactment of 1960 Dowry Prohibition Act of 1961 was passed, but still it has been observed more in breach rather than observance. Then the question is, the definition of dowry is means any property, a valuable security given or undertaken, agreed to be given either directly or indirectly by one party to the other party, by the parents of either party to the marriage of any other party, or other party to the marriage of any other person. Here, what do you mean by dowry? Dowry means any amount which is agreed to be paid in consideration of the marriage, or in consideration of giving the girl in marriage to the boy, or any presents that are agreed to be given at the time of marriage, or any property that is agreed to be settled towards the marriage settlement. All these things, and even including your utensils, ornaments, gold, silver, and so on and so forth, which is given in contemplation of marriage as per the demand made by the other side, the expenses that are incurred at the time of marriage, or the lavish reception that is hosted after the marriage, all these things come within the definition of the word dowry. So, giving of dowry and taking of dowry is prohibited under this act. But please remember, experience has shown that this evil has not been eradicated till now. Then penalty for giving or taking dowry is after that is 15,000 or amount of such dowry, whichever is higher. That is, which shall not be less than 5 years. As far as section 3 says, if you demand dowry, that is giving or taking dowry, both the recipient as well as the giver are liable to be punished under section 3 to the extent of 5 years and fine. And fine also is imposed, that is not exceeding 15,000 rupees. Fine is imposed. So now it's become a penal offense also under section 3. Giving of dowry and demanding dowry is punishable. Then section 4, which you find mostly in courts today. Section 4 deals with what is called section 4. Yes. Penalty for demanding dowry. That is 6 months punishment, and or it may extend to 2 years, and a fine which may extend to 10,000 rupees. As far as demanding dowry is concerned, under section 4, it is said 10,000 rupees fine can be imposed, and also 2 years imprisonment, that is 6 months imprisonment, up to 2 years also it can be extended, and this is a harsh punishment as far as demanding dowry is concerned, and this is provided in section 4. Then, sir, section 5. Section 5 deals with agreement for giving or taking dowry to be void. Agreement for giving or taking dowry to be void. Suppose this happens in most of the communities which are conservative in nature. They reduce it in the form of writing. The amount that is agreed to be given, amount which is likely to be given to the boy in consideration of marriage, or even agreement that is giving or taking dowry is void. That is, any agreement which provides for grant of dowry is prohibited. Please remember, I conducted one of the defenses uh, in the criminal court, where 4 and 6 of the Dowry Prohibition Act also was there. I still remember vaguely that there's a bench judgment of the Supreme Court rendered by Justice Shah Mohammad Qadri and some other judge, which says as far as to constitute dowry or punishable for dowry, there must be an agreement between the parties for giving dowry either prior or after that, and that is it's that one, unless there is an agreement, dowry is not proved or established. That's a very conservative judgment, sir. No one is a fool to reduce it to writing. And even if such an agreement is made, it cannot be enforced. Then dowry to be for the benefit of the wife or her heirs. Here, section 6 says anything that is given at the time of marriage, anything that is given as a marriage presentation, any ornaments that are given in consideration of marriage, any cash that is given at the time of marriage, the marriage expenses which are incurred, and the all these things are for the benefit of the woman. And if the marriage breaks down for any reason, these things in the money value has to be returned back to the bride and the bride's parents. So then, sir, we have got section 7. Section 7. Section 7 deals with cognizance of offenses. Cognizance of offenses. First and foremost, you must know where a case for punishment lies as far as the DP Act is concerned, the Dowry Prohibition Act is concerned. It lies before the magistrate who has got the power, where the marriage was done, where the parties live together, or where the dowry was given, within whose jurisdiction it comes, which is the police station within which it comes. Then it is the concerned magistrate of that particular area who can entertain or take cognizance of a complaint under section 4 and 6 of the Dowry Prohibition Act, and the court shall take cognizance of offence under this act except upon its own knowledge of a police report of the fact which constitutes such offence. Normally, it is preceded by lodging a police complaint to the police, and the police takes cognizance of it and refers it to the magistrate, and the magistrate directs the police to take up investigation and investigate the matter. Why I am giving so much of importance to this is now under the new BNSS Act, it is said that as far as filing of private complaints has now been made an exception. You cannot file a private complaint under section 192 and 200 old CRPC. Today, if any private complaint is made, the court will not take cognizance. Court, what it does is it issues summons to the accused, and the accused has to be heard before the cognizance is taken, and then only the case will be registered. Or filing of private complaints are today shunned. Then burden of proof, where any person is prosecuted for taking or abetting dowry, demanding dowry under section 4, the burden of proving that he has not committed the offence under those sections shall lie on him. This absolutely under the Evidence Act, you cannot be called upon to prove a negative. But under this Dowry Prohibition Act, the burden of proving you have not taken dowry is on you as a husband. Please remember, no one pays dowry to a wife. It is only dowry which is payable to a male. So the question of burden of proving that you have not taken any dowry or you are not abetted in demanding dowry or taking dowry, it is heavily on you who allege it. So a negative has to be proved by the husband. Then this is the question is, as far as rules under the DP Act is concerned or the Dowry Prohibition Act is concerned, the powers are vested in the central government as well as the state government, and the cognizance of the complaint can be taken by the magistrate of that particular area, and on the report given by the police officer where a complaint has been made, and a charge sheet will be filed, and the case will go on according to law. So this is as far as your Indian Divorce Act is concerned and the Dowry Prohibition Act is concerned. Dowry Prohibition Act consists of only 8 sections. That's the reason why I handled it today. And tomorrow, in more probability, I will be taking up the new Hindu Succession Act of 1956. Any questions in interaction, please?
Any questions?
Sir, good evening, sir.
Yes, be a bit loud, sir.
Yes, sir. Good evening, sir.
You
said burden of proof lies with the husband in the case of.
No, you are talking about the Dowry Prohibition Act.
Yes, sir.
Under the Dowry Prohibition Act, the burden of proof is on the accused, that is the husband. That to say that he has not demanded dowry, he has not taken any dowry, nor any dowry was paid, nor any marriage presentations are made, or any abatement of dowry was also made. So it's a very unique provision where the burden is on the other side, not on the wife. Even in the, I could give you one provision in the criminal law, sir. There is one act called the RPUP Act, that is Railway Properties Unlawful Possession Act. That means, suppose any railway property is found in your compound, the burden of proving that you are not the thief, but it has come by accident, is heavily on you. In the same way, under the Dowry Prohibition Act, the burden is on the accused, on the husband to prove his innocence, not on the wife, sir. There was a demand for dowry and there was a payment of dowry, and the question is that has to be proved.
Yes, sir, that's what I.
Yes, sir. It's a very peculiar provision, sir.
Yes, sir. Normally,
the wife has to prove. Wife has to, yeah. But please remember, now they are very careful, sir. What they are doing is they are noting down the list of items that are given at the time of marriage, the money that is given at the time of marriage, the presentations that are given at the time of marriage. Like Muslims, they maintain a list called list of presentations. In Muslims, you have got a list called Jahez list. Jahez means what is given in contemplation of marriage. And when the marriage breaks down, all those items will have to be returned back to the opposite side. We have also come to that level now.
Yes, sir. And this DP Act is applicable for
yes.
Hindus, Muslims. Is this DP Act applicable for Hindus, Muslims, and Christians?
DP Act, among Muslims, there is no dowry, sir. But as far as Christians are also concerned, there is no dowry. That evil exists only in our Hindus.
But it is called in a different
meher.
Meher is an amount which is promised to be paid by the husband to the wife. It's not the wife paying to the husband. The husband pays, it's not dowry. Meher is in consideration of marriage and in consideration of the wife performing the conjugal duties, sir. I don't want to be still
All right, any more questions for today? Sir, Venkat Garu, you asked something in chat box. Please go ahead with the question, sir.
Good evening, sir.
Good evening.
Sir, as far as interim maintenance is concerned, sir, so if at all, if there is a change of means, at which point of time we need to again show
the question is, you can also ask for alteration, you can also ask for modification, reduction of maintenance also in case the situation changes. You do not get that money what you were getting earlier. I think I remind you of the case of Bangalore. I think most of you must have read, but not under the Divorce Act. It was under the Pendentility Section 24 of the Hindu Marriage Act, where the wife demanded 6,15,300 towards her monthly maintenance. And unfortunately, the judge was a lady. And the judge just remarked, what is the breakup? How much she wants? She said that she wants 3 lakhs for her, what is called physiotherapy, 50,000 for her cosmetics, and for colored chappals and matching chappals and matching blouses and all, so on and so forth. Judge said, I do not get that much money. How could this lady get 6,15,300? Then the advocate said, sir, things have changed. I'm not bothered about my children. She's not bothered about the children. She says she wants to.
She mentioned something for tuition fees as well as school fees also.
But the children are in the custody of the husband only. The husband is taking care of them. And the judge said, you give the breakup. And the judge was aghast by saying, does it take 50,000 for cosmetics? And that lady was also having what is called problem with her niece. She wanted 3 lakhs for her physiotherapy. And the judge was just laughing and said, I'm going to dismiss it. Then the advocate said, sir, I'll file an affidavit to show the breakup. Then the advocate for the husband, that is what she was a lady, she said, sir, she has got 65,000 shares in a particular company. Sir, I'll also file an affidavit. And the judge said, if you are so qualified, you can earn yourself and make the money. Why do you make the husband a scapegoat?
So again, for the alterations, we need to file under the section 24 itself, sir.
Not section 24, sir. It's if you go under the CRPC, it's section 126, whole section. 127, I'm sorry, alteration of maintenance.
All right, Mr. Yasar. Mr. Yasar. You have some question in there.
Yes.
Please be a bit loud.
Sir, namaste.
Namaste, sir.
Sir, Christian wife, he wants to file RT, sir.
Yes. Under which act?
Yeah, the Indian Divorce Act or...
No, sir, please be a bit specific in your question, sir.
If Christian woman wants to file
If a
an
Christian
RCR,
woman wants to file, she has to go under the Indian Divorce Act only. If I'm correct,
RCR.
it's RCR is section 36 of Indian Divorce Act.
Indian divorce. And Special Marriage Act also there, sir. Restitution clause.
Special Marriage Act also you got a provision, sir. You can look in the provision. I've already discussed it. Even in what do you call, even in Hindu Marriage Act, section 9, and in Special Marriage somewhere at 12 or 13. But in the Indian Divorce Act, section 36.
Yes.
All right, and Selina, please ask your question.
Sir, is it compulsory to file income declaration form as per?
It has now been made mandatory, madam, especially in maintenance cases. I do not know about the matrimonial cases, but in maintenance cases, it's absolutely compulsory now. Both on both sides. On both sides.
Yes, sir.
Selina, madam, please go ahead with your question. Right. We conclude the class for today. Thank you.
Any more questions?
Any more questions for today? All right. Thank you.
Close that. Your questions are there.